Hi folks, Steve Marlowe here from Marlowe Law Office, talking about small businesses and bankruptcy. If you're a small business owner facing a likely Chapter 7 or Chapter 13 in Ohio, settle in. You should have worried about this before starting the business. But we never do we? Then it's all optimism, hope, and future IPOs. So don't feel bad. You've made the same mistake that plenty of other people have made. Keeping your business and personal lives as separate as possible, at least those financial aspects, by creating a corporate entity, a Frankenstein's monster if you will, to do your bidding is a very good idea. This is quite difficult as it involves a species of invited multiple personality disorder. You write checks from an account for your business and deposit them into your personal account. You write promissory notes to yourself. You remind people not to make their drafts out to you, but to Anonymous Widgets Incorporated. Crazy, but useful. If your small business is bankrupt, but you're not, and you intend to stay in business, you should read up on Chapter 11. Otherwise, we're going to talk about Chapter 7 and Chapter 13 and how those relate to your business. If you're a sole proprietor, you are your business. What debts you've incurred as a DBA, you'll have incurred as a person, just the same. What assets you've accumulated as a person support your business. In other words, your house, like your butt, is on the line. Same with a general partnership, except another person has the power to make mistakes or commit crimes for which you're equally responsible. That's why nobody who's been properly advised does business under these forms anymore. The best way to keep your business and personal life separate is to create one of those Frankenstein's monster type entities we know as a corporation, a partnership, a limited partnership, a limited liability partnership, or a limited liability company. In the modern world, there's no sense in creating any of these golems other than a corporation or a limited liability company. If you're doing business in 14 countries, you plan to raise trillions in capital, or you're raising polar bears trained in kung fu to work exclusively in dynamite factories, then you might think of taking advantage of the hundreds of years of brightly demarcated law where a person ends and a corporation begins. Sometimes a C corporation will help with tax concerns, but in almost every other case, limited liability companies are the way to go for small business people. An LLC is the only entity to ever beat the IRS. They came of age when the IRS threw up its hands at trying to ferret out all the ways Americans were sneaking their cash past the corporate tax vacuum. LLC tax liabilities do something called flow through to the recipients of the cash, instead of being taxed twice like a corporation is. A corporation is taxed once as a person and once when the shareholders receive their stock gains and dividends. An LLC allows the profits to flow directly through and not be taxed at the corporate level and go right on to the members of the LLC, which are akin to shareholders in a corporation. Note, however, that the IRS holds all business owners personally liable for unpaid payroll taxes regardless of the structure, so you can't get off the hook for those no matter what you do. An LLC is cheap to make. Any person, even one person, can form one, and it completely separates your business and personal affairs, offering complete liability protection for actions taken as a corporate entity. Business-wise, it's heaven. Now let's say you formed a corporate entity, but like many small business owners, when it came time to get credit, the bank wouldn't work with you unless you were willing to obligate yourself personally. Now we have to invoke the multiple personality disorder metaphor again. You and your business co-signed on the loan. Your LLC or your corporation might be bust, and the bank will be eyeballing your boat or your baseball card collection or your late mother-in-law's neon-colored beehive wig collection when it comes time to collect. If you file a personal bankruptcy or own a business, your share of the business is a personal asset. If the business is healthy, your share can be sold for the benefit of creditors in a Chapter 7 bankruptcy. In a Chapter 13, you can pay off all your debts over a 3 to 5 year period and protect what assets you have, including those business interests, especially if they're helping to produce income with which you fund the plan. Chapter 13 bankruptcies are best for people with high constant incomes or who have assets they really want to keep, like those neon-colored beehive wigs. Upon the moment of bankruptcy filing, the court always orders something called an automatic stay. Think of this as a referee's timeout whistle. All action, including the ticking of the clock, stops. No one may collect from you, or even contact you for the purposes of collection, and no creditor can sell foreclosed property if a bankruptcy case is filed, up until the nanosecond before the auctioneer's gavel falls. Be prepared. This has significant effects on your business if you're filing a Chapter 7 or Chapter 13, both in terms of how you can protect yourself and also the liabilities that you have. The best way to prepare for a small business bankruptcy is to plan ahead and not have a small business bankruptcy that relates to your personal property and asset in any way more than it has to. You need to build your monster and let it handle its own affairs. You be you, and your LLC is your LLC. If it goes under, you don't have to. And if you go under, it can save your behind. If necessary, resort to the protection of a Chapter 13 in order to protect your ownership interest. If you're worried about your finances as they relate to your business or your personal life, call Marlowe Law Office for a free consultation. Our number here is 937-506-0505. That's 937-506-0505. Or click the link at the bottom of your screen and it'll take you right to our website. Thanks.